homelessness. She has facilitated workshops and trainings for families, child serving professionals, and community partners on the laws and best practices for ensuring equitable access to public education. And she also has experience teaching elementary school students and is a graduate of the Northwestern University School of Law, where she was a recipient of a public interest fellowship. Welcome, Hitul. I will kick it over to you. Thank you all for being here.
Thanks so much, Megan, and thank you to the PA Department of Education and the Center for Schools and Communities for inviting us to talk today. I'm going to go ahead and share my screen and get started. Like Megan said, I will make sure she has these slides. I'll make sure to keep those links clickable so that you can have resources that might be helpful to you. And with that, let me get my screen up. Let's go ahead and get started then. So we, the Education Law Center, we're a nonprofit legal advocacy organization. It's our mission to ensure that all students in Pennsylvania have access to a quality public education. We use a variety of different strategies to advance that mission: legal representation, we do larger systemic litigation, policy advocacy, and community engagement, both for families, for students, for advocates, and teachers, educators, anyone really working in this space that can support children. We focus on those children who are least served by the public school system. So students with disabilities, LGBTQ plus students, multilingual and immigrant learners, children in the foster care system, those experiencing homelessness, and of course, children who sort of are experiencing those multiple identities. We do have a helpline for parents and advocates to call, just so you all know. We have a Western PA, Eastern PA call-in line, as well as an online intake form. If you call the wrong office, we will make sure that we get you to the correct office. We have offices in Pittsburgh and Philadelphia, and so we cover the state that way. We have a back to school guide I wanted to flag for you all. We've got fact sheets on the most commonly requested topics to our helpline. So questions on what's the law on special education, enrollment, attendance, discipline, you name it. We've probably written a fact sheet on it. And many of those fact sheets have been translated into multiple languages. So if you have Spanish speaking families, Arabic speaking families, Mandarin, we have a couple other languages on there. We try to sort of hit the high incidence languages in some of our larger school districts. But we do recognize that, the languages we need can sometimes vary year to year, depending on where populations have been moving from into Pennsylvania. I later at the end of this PowerPoint, I do have hyperlinks to our specific fact sheets on some of the topics that we'll be talking about today. But I also just encourage you to take a look around some of those fact sheets to see if they can be helpful to you and the families that you work with. So today we're focusing really on multilingual learners and enrollment, but I was asked to also just sort of set the stage in terms of bigger picture and the rights of our immigrant and multilingual learners in schools. So I'm going to very briefly touch on enrollment and then go a little bit into the current state of the law, which, I'll preview for you, has not changed in many, many years in terms of the requirement to make sure that students who are learning English have meaningful access to public education. And now my neighbor is mowing their lawn, so my apologies if you get that background noise. So who can enroll a child? It can be a parent, a foster parent, a caseworker, a caregiver. Everyone knows we have Section 1302, which means it can be someone who says that they are caring for the child year-round without compensation. That individual can also sign an affidavit and enroll a child in school. Families do have the right to interpretation and translation during the enrollment process. We found that to be particularly difficult with so many schools transitioning to online enrollment processes, because families don't, come to the front desk anymore with all their documents and show things. And so there has been some confusion there. So I would encourage schools, and I know advocates have always stepped in to help families also, but to make sure that there is that option and that it's very visible to families that if they need assistance during enrollment, that language assistance will be provided by the school. We know that those enrollment documents are going to contain a home language survey, which is, of course, a starting point for identifying that perhaps you have a student who is an English learner. Once those documents are provided, and those documents, we're talking about proof of residency, proof of age, the disciplinary document. Just a reminder, proof of age does not mean birth certificate necessarily. That is one way to demonstrate proof of age, but there are other documents that Pennsylvania Department of Education deems appropriate for demonstrating proof of age of the child. But once those documents are provided, children should be enrolled the next day or within 5 business days. If you have a child who is experiencing homelessness or in the foster care system, that enrollment should be immediate, even while the documents are still being obtained. Older students have the right to attend school until age 21 or until they graduate, whichever happens sooner. So that means if you do have a learner who leaves school, they are permitted to re-enroll in school if they have not yet graduated until the age of 21. We're talking about students with disabilities today. So I want to flag that students with disabilities, if the IEP team decides, may be able to stay in school until age 22. Ideally, during the enrollment or very close to after the child is enrolled in school, we'll start talking about the child's needs, special education, English language development, and credits for graduation. Credits for graduation comes up a lot with the English learner population, particularly for those students who are joining school and maybe have had interrupted education or sort of have a different credit structure that they're coming from. And sometimes families are sort of surprised. I think there might be a little bit of a breakdown in communication where families are surprised at the end of the year to learn that their child is not graduating and also has aged out of the school system. So it's important to sort of have those conversations as early as possible in the academic year. So there can be discussions about, for example, is credit recovery even an option? Do we need to, for example, look into Act 1 if this child is eligible under Act 1? Just having those conversations early, I think, avoids that surprise at the end of the year where we get calls from families saying, wait a minute, my child hasn't graduated. What do you mean they can't go to school here anymore? And we have to, of course, explain what the law is. Immigration status. I bet everyone on this call here already knows, but schools cannot require information about a student or family's immigration status. Like we said, we've got 4 in the door in terms of what's required for students to enroll in school, proof of residency, proof of age, those immunization records. There are certain grace periods for those immunization records. For example, if you have a student transferring in from another district or out of state, there is a 30-day grace period to get that documentation and or catch up with those immunizations. And of course, like we mentioned, there's also the statement about the student's prior discipline history. One of the points we just want to note is that schools also can't require, in terms of, determining residency or age, can't require specific documents that only people who have U.S. citizenship or immigration status can actually have. So not requiring, for example, a U.S. passport, not requiring a driver's license. Again, there are many other ways that families can provide documentation to demonstrate residency or age. Sometimes we see questionnaires and enrollment documents that, have very innocuous reasons. For example, we had a school that was asking parents to share when and where their child was born, or what year did you, if you weren't were not born in the United States, at what year did the child enter the United States? And all of that information was really, I think, from the school's perspective, meant to glean an understanding of how much US education this child had been exposed to. But at the end of the day, and unfortunately in this current climate, those are the kinds of questions that we need to think twice about in terms of like getting any of that information in writing and then having it become part of the student's file. McKinney-Vento students, those who are experiencing homelessness. So for students who are experiencing that lack of consistent, adequate, fixed nighttime residence. So they're living in a shelter, living in a car, they are couch surfing, or maybe are living in very, very substandard shelter at that time, may be considered McKinney-Vento eligible. We have unaccompanied youth who can also be McKinney-Vento eligible, and certainly our English learners can oftentimes fall into that category also if they are experiencing that lack of consistent, adequate, and fixed nighttime residence. In the event that our students are McKinney-Vento eligible, excuse me, those students do have that right to school stability under the federal McKinney-Vento law. So they can stay in their current school or attend the prior school they attended. And that can go until the end of the school year until they have that stable housing. And again, as we mentioned before, those students are going to have that immediate enrollment into school without having to wait for all of the additional documentation. And students can be McKinney-Vento eligible regardless of immigration status. So let's launch into now K through 12 language access and what that means for multilingual learners, and then we'll blend into special education. So we've gotten a lot of questions lately about sort of what is the current state of the law for immigrant learners. It feels like there's a lot of information out there, a lot of executive orders being published, and also some federal guidance being rescinded. So I always like to remind folks that Title VI of the Civil Rights Act of 1964 is still in full effect, which says that no person in the U.S. shall, on the grounds of race, color, national origin, be excluded or denied equal really participation in any program receiving federal financial assistance, which of course would include our public school system. Lau v. Nichols was a really big case about English learners. So in that case, which was ended up being a Supreme Court case, the school district of San Francisco said, we know we have this very large population of Chinese students. They have equal access to all of the classrooms, all of the books, all of the courses. We are not denying them equal access to our education system. And many of the Chinese students banded together and said, that's actually not equal access if we can't even understand what's going on in the classroom. And there, the unanimous Supreme Court in 1974 held that a school district's failure to provide that English language instruction violated Title VI because there's no way that just giving them the same access to books, materials, courses offer them a meaningful opportunity to participate in public education. And so I really like this quote from the decision itself, which said, there is no equality of treatment merely by providing students with the same facilities, textbook, teachers, and curriculum. For students who do not understand English are effectively foreclosed from any meaningful education. So the Equal Educational Opportunities Act of 1974 essentially codified that decision from the Lau v. Nichols case. And it then just said no state can deny equal opportunity to any student based on their race, color, sex, national origin by failing to take appropriate action to overcome language barriers that impede equal participation. So then the question is, well, what does that need to look like? What is this language, access? How do we overcome language barriers? What's the standard? How much do we as a school have to do? And really the prevailing test that's used came out of a case called Castaneda v. Picard, which was actually a Fifth Circuit case. And there the court held, in order to comply with the Equal Educational Opportunities Act, a school district must have an English language development program that is based in a sound educational theory, be given adequate resources to be implemented, and then it needs to be proven effective. So those are the sort of three broad measures that we have for determining really whether an English language development program is going to meet our standards for helping ELs overcome language barriers. So in terms of English language development, we need to make sure that that instruction is grade level appropriate. I wrote in there S-Life considerations. S-Life stands for students with limited or interrupted formal education. Oftentimes, when we have students who are coming from outside of the country and joining our public education system, they have had different formal education. They may have had years of interrupted formal education where they weren't able to go to school regularly. I recognize that there can be some challenges in terms of understanding where do we place this child, what grade do we place them in, with an understanding, of course, that we don't want to place high school children in elementary school classrooms. We know that's not going to happen, but there can be a lot of challenges in terms of placement of those students. The Department of Education has a BEC about English learners and English language programs, noting that English learners, of course, must have equitable access to academic content for all courses in which they're enrolled. Again, no matter what English language development program a school chooses to use, that school-wide program needs to have, at a minimum, these bullet points here. So it needs to be aligned to state academic content standards. It has to include English language development instruction delivered by properly certified teachers or who are working in conjunction with ESL certified teachers. It needs to incorporate the use of the PA English language development standards, provide equitable access to content for ELs at all language proficiency levels by providing research-based bilingual or sheltered instruction with fidelity. And there shouldn't be any enrollment of ELs in any course or academic program for which they would otherwise be eligible. A note that an English language learner should never be retained in a grade solely based on their lack of English proficiency. And when English learners are exited from the program, they really must be monitored for academic progress for at least 2 years, just to make double, triple sure that exiting the program was appropriate. Generally speaking, schools need to share information with multilingual parents in a language that they can understand. That means the schools are providing free interpretation or translation, ideally by a trained translator. I recognize that can't always happen, but that really is the ideal. Parents are entitled to language services in all interactions with the school. I know a lot of schools are using apps these days, a lot of text to talk communication, which can be really helpful if we're working with parents who are also pre-literate. And so it doesn't really matter what language you're sending them information in. These text to talk apps can be really helpful in terms of making sure that there's two-way communication. Districts are also responsible for communicating with multilingual parents on how they can be involved in their child's education. So making sure that information about school nights is pushed out to parents is really, really important in terms of just fostering community and allowing that participation in their child's education. We can move into special education now. So,
Oh,
Bradley,
sorry.
yes.
Hito, I was wondering if now would be a good time to pause. We have a few questions from that
Okay,
first section for you.
sure.
So the first question, Brittany asks, I think she was talking about the aging out. So is it until they turn 21 or the year in which they turn 21? So for example, if a student turns 21 in December, do we educate until that school year is complete?
Um, Until they turn 22, age 22. So throughout age 21. Yes.
Okay, thank you. And then this was a question about enrollment. So Megan says we ask when students enrolled in a US school so we can get appropriate state testing accommodations. Should we not be asking this?
We're recommending that if there are other ways to find out that information, to just give pause in terms of what you're putting into school records.
And then last question, do you know if asking for residency documents applies to grant-funded early learning programs?
Um, Early learning, I honestly don't know the answer of that off the top of my head, but if Megan, I'm assuming you have all these questions, so I can look into that. Some of the questions, that answer may depend on whether that center receives federal funding, but
Okay.
I don't have the specific answer for that right now.
Okay, thank you. Yeah, and if your question wasn't answered fully during the Q&A session, we can unmute and talk about it further if you'd like. Thank you.
Yeah, thank you. So special education, broad headings for what we're going to be talking about today. Multilingual learners with disabilities have the right to receive both special education and ESL services. There is no waiting period. You may hear me say that a couple of times now, but we don't want to be in a situation, and I have seen this coming up quite a bit recently, where you have a student and maybe there are advocates, maybe the student's own parent are saying, I'm really concerned about my child who's struggling in school and not making any progress. And the school saying, you know what, it could be language, let's wait and see. Because we certainly don't want to over identify students as having disabilities when really it's language access that is the issue. And I just want to point out that an effective special education evaluation is going to and should be able to tease out if a child isn't making progress, why they're not making progress. And that a really effective evaluation must take into consideration the student's language ability as well in order to piece out, is it disability? Is it language? Is it interrupted education? Is it they're learning virtually and that's not a good setup for them? Or is it perhaps a combination of all of those factors or some of those factors? So I stress again, and this is also on the PDE's own back where it says there is no waiting period for doing a special education evaluation if the student is suspected of having a disability. Special education evaluations, gold standard, they're done in the preferred language of the student. We recognize there aren't a lot of school psychologists that maybe speak a very, very specific dialect from another country. And so, the next best is, can we get a qualified interpreter who maybe is more also familiar with cultural norms, who might be able to assist during the evaluation itself. Here are some of the key rights of children in special education, right? The IEP needs to be revised each year. It's got to provide FAPE, that free appropriate public education in the least restrictive environment. We'll delve into what those two concepts are momentarily. And we want to make sure that those services ensure that students get a meaningful benefit in all of their areas of need. Students who have an IEP and a 5 or 504 have fairly strong disciplinary protections above and beyond what other students have. Meaning that if a student with a disability is facing discipline, we need to figure out, is that behavior a manifestation of their disability? Because we cannot exclude students for behaviors that are related to their disability. Families have the ability to disagree with special education decisions that are made by the IEP team. There are due process considerations. And if a child is deprived of that free, appropriate public education, the remedy is compensatory education, which are makeup services. Essentially, can we make up the actual services that this child was owed. For example, can we do tutoring to get them where they should be? Maybe I've seen schools add extra time to speech if they miss those speech hours. So we can delve into that in a moment. Again, students need to be educated in the least restrictive environment. They have a right to pendency, and that concept of pendency, which there's a lot of case law around, essentially means that if there is a dispute about school placement, those students have a right to remain in the same placement pending the outcome of the dispute. So we don't change a child's placement if there is a dispute about it. When children change school districts, they have the right to comparable services until the new district either adopts the old IEP, or I should say the transferring IEP, or creates a new IEP. All parents have a right to meaningful participation, and that when I say parent, I mean the definition of an IEDA parent, which includes an education decision maker or surrogate parent as well. Students have the right to remain in the same classroom placement if the conduct the child is being disciplined for relates to their disability. There are exceptions, for example, if the incident involves a weapon, drugs, or serious bodily injury. What is a FAPE? We hear FAPE all the time. It can be a little bit of a difficult concept to really understand. Free means exactly what you would think it means. It means all special ed programs, related services, all of that needs to be provided free of charge to the family. Appropriate means what programs and services, supports give the child an opportunity to make meaningful progress in light of their disability. So I really like this statement here at the bottom that I think encapsulated what FAPE is. It's a planned program of education and special services that takes account of a child's individual needs. So an appropriate program would be one that allows the child to make meaningful progress and to prepare for employment and independent living. And what that looks like, of course, and there's a reason why it's called an individualized education program, is going to look very different from child to child. Least restrictive environment. Federal and state law says that students with disabilities must receive their education to the maximum extent appropriate with their non-disabled peers. And that is that concept of inclusion. So students in special education or receiving special education should not be removed from the regular classroom unless even with those supplemental aids and services, they still can't make progress in the general education classroom. Research has shown us that inclusion is beneficial to both students with disabilities and their non-disabled peers, academically, social, and emotionally, and it prepares students for a more integrated community. The IDEA also talks about English learners, the Individuals with Disabilities Education Act. So it talks, for example, that assessments and other evaluation materials used to assess a child under the section must be provided and administered in the language and form most likely to yield accurate information, unless it's clearly not feasible to do so. Again, I've worked with children who are older, but still pre-literate. And, we've had to rely more heavily, for example, on those verbal assessments. So it really is important to craft that evaluation so that it gets the information, as much information that you can about those child's abilities and achievement and present levels. The IDEA also says in the case of a child with limited English proficiency, the IEP team must consider the language needs of the child as those needs relate to the child's IEP. I was helping a family the other day and came across, and understood that the child was an English learner and came across the IEP and thought, oh, well, through this IEP, I'll be able to understand their WIDA scores, their level, like where are they in terms of learning English? And there was not one mention in the IEP about their English learner status. And that, of course, we really need those two different programming elements to be working together because, of course, the supports and services the child is going to need in their classes is going to also involve their English language development program as well, and vice versa. So, in addition, the public agency must take whatever action is necessary to ensure the parent understands the proceedings of the meeting, IEP team meeting, including, again, arranging for an interpreter for parents so that really key parent participation piece gets an added section here on that language access. So evaluations for multilingual learners. Here's sort of our semi-flow chart. If a multilingual learner is suspected of having a disability, then the school district must promptly evaluate the student. Again, shouldn't be delayed due to language acquisition levels. Must also consider those language acquisition levels when designing the evaluation and choosing assessments. Consider cultural differences in terms of the assessments that you might choose or how they're administered. Ideally, gold standard, it's obviously each evaluation would be administered in the child's first language. We understand that might not be possible. So are we using a trained interpreter? When I've been in situations where I've had to use an interpreter, I make sure I have a pre-conversation with them if they're not accustomed to education and in particular special education. I'm just going to put it out there that there can be a lot of language in IEPs and the way they're structured, that it's not always easy to do a one-to-one interpretation and have that title heading, for example, still hold the same meaning. And so I like to be able to explain some of the concepts to our interpreter beforehand to say, like, here, now we're going to talk about the supports and services. This is what that means. This is what special education is, because maybe just translating special and education does not actually convey what we're talking about that day. So if there's a chance for that interpreter to be able to do a little bit of pre-work to get up to speed with the terminology they might want to use to be able to best convey what we're talking about during that meeting, that's always a plus. And then, of course, when we're interpreting the results of an evaluation, that school psychologists and the rest of the team really needs to have the expertise to determine whether evaluation results are due to disability, language acquisition needs, or both. Just really quickly, for an IEP, for a student to be eligible, it's a two-part test. So the student needs to have one of the identified and enumerated disabilities listed here and in the law. And because of that enumerated disability, require specially designed instruction. To qualify for a 504 accommodation plan, I think we just all call them 504s. They must be a student with a mental or physical disability that substantially limits one or more life function. And then a 504 offers a child reasonable accommodations or supports in the general education classroom. One of the categories for an IEP is other health impairment, and we always get questions about what other health impairment is. It means a student who has limited strength, vitality, or alertness. So it could be the symptoms from a chronic health condition like ADHD, asthma, diabetes, lead poisoning, etc. It does include heightened alertness to environmental stimuli that reduces alertness to the educational environment. But we often have parents say, but my child was diagnosed with ADHD. The school says they don't need an IEP. How can that be possible? And we have to explain it is that two-part test. It's not just the child has a disability, but because of that disability, they are in need of specially designed instruction. And that's what the evaluation is designed to tease out. Here are some signs that a student may need an evaluation or a reevaluation. There has been an outside evaluation that diagnosed the student with a mental or physical health condition. Maybe their doctor's records, therapy records that the parent shares. There are partial hospitalization records that have been shared, DHS case records. Maybe there's a long-standing medical diagnosis that impacts the child's education. The example given here, ADHD diagnosed in the first grade, and we've had so many suspensions throughout the year. That may be a flag that the child needs to be evaluated. It could also be a chronic health condition. If you have a child who has a health condition such as, let's say, sickle cell anemia, where you don't know, where the child and the parent doesn't know when the child is going to have an extreme medical issue, and then, generally speaking, would have to go to Children's Hospital or whatever hospital in order to have treatment. That could be a reason why you're saying to yourself, okay, we need to evaluate this child, see whether they need an IEP or 504. If a child has been held back, not promoted to the next grade, that should be a flag to think about as well. If the child has had frequent absences from school, it's helpful to get to the root cause of that. You'll see later on in the slides, I just think it's so important that if we have non-attendance of a child and we want to get to the root cause, if that child has a disability, it's so important for the IEP team to be part of the conversation, because it can identify root causes, it can maybe identify supports and services, but we've just unfortunately been in situations where it's like, whoever's in charge of attendance isn't always communicated with the IEP team, and then we have a family that's been referred to truancy court, and then the IEP team is playing catch up and saying, "Oh, we would have wanted to be a part of this. We would have wanted to be a part of the solution before this child was referred for truancy." If there's data, obviously, indicating that interventions are necessary, grades, testing, teacher report, parent reports, unmet academic or behavioral needs. Obviously, a fifth grader who doesn't know all the letter sounds, hopefully we would have caught it earlier than fifth grade. That's an extreme example, but there you have it. Also, if you have a student who needs to develop a fundamental academic or behavioral skill. So, for example, if we have a third grader who still is working on their toileting skills, that may be a flag that that child needs to be evaluated. Here's a fun true or false. I know there's quite a few of us, so I won't I won't ask everyone, but maybe to yourself. A child does not need to be evaluated for special education when he's getting A's and B's in school. Think through that. So it's false. Grades are certainly a factor, but they are not the determining factor. So, there can be a child who seems to be getting straight B's across the board. But, the question is, do they have a disability in need of specially designed instruction? It's possible that they don't, but, sort of cutting off that discussion, particularly if, for example, you have a child who has unmet behavioral skills, but they're getting B's, but they're also getting suspended a lot. That might be a flag that that child needs to be evaluated. That information about special education evaluations, of course, they are free. Parents need to provide permission to do that. They will sign, of course, in the child's preferred language, like I said, and also preferred dialect if at all possible. For example, if you have a child and it's, oh, well, he mostly understands Spanish, although his family speaks a different, indigenous dialect at home. If we really want to understand the child's present levels, we need to get to that indigenous first language for the child, not the he gets by with Spanish, so we'll just use Spanish. It needs to be done by a knowledgeable professional, multifaceted, right, in all areas of suspected disability. Parent input is so valuable in these situations. Should be completed within 60 days from the date that the parent signs the permission to evaluate. That, of course, does not include summer days. But as we'll talk about in just a little bit, for students who are highly mobile, the recommendation is that those evaluations are done within 30 days. Oh, and here we go. Perfect. So the Office of Special Ed and Rehabilitative Services explicitly recognizes that evaluating highly mobile children, meaning McKinney-Vento children, those in the juvenile justice system, those in foster care or the dependency system, that evaluating those students may be a little more difficult because of their frequent moves. Because of that, OSERS does strongly encourage school districts to complete their evaluations of highly mobile children within 30 days rather than the 60-day time period. Some considerations for multilingual learners for the IEP itself or the 504 team. Since the family is part of the IEP team, of course, we're going to need those trained interpreters for meetings and to be able to translate those documents. The IEP, as I mentioned earlier, should be inclusive of the student's English language development needs. Ideally, the ESL teacher is also part of the IEP team. As I mentioned, the IEP should really provide the student's current language proficiency levels, make sure all of that is taken into consideration, and talk about how the special education supports and the student's language acquisition levels are going to work together, what language are all of these supports going to be provided in. All of that information should really be spelled out in the IEP itself. One more true or false. Attendance issues, truancies should be addressed by the IEP teams or in a child's IEP or 504 plan. That is true. So if a student is experiencing attendance issues, then the IEP team should meet and discuss and offer additional supports, or you can revise the IEP or 504 plan in other ways. Ideally, we have staff who are responsible for truancy matters attending this meeting so that we have groups talking to each other and one train isn't moving ahead of another train because the whole point of truancy is to get a kid back in school. So, according to the PA Department of Education, a school may diverge from its general attendance policy in order to ensure that all students with a disability are provided with FAPE. So what that means is not that, okay, that we can give students with disabilities shortened school days, that's good enough. That's obviously not what that's going for. It's more in light of the student's disability. For example, let's take our child with sickle cell anemia example. We as a school recognize this child is going to have frequent absences. Maybe they get a doctor's note for everything, but there may be instances when they are not able to do so or not able to do so within the 3 days that they need to provide that medical note. Like, what can we provide in this IEP that gives an accommodation or a modification to attendance, recognizing that it is absolutely attached to providing FAPE in light of their disability. Some students are twice exceptional, always want a flag. Students can receive gifted education and special education. The Department of Education strongly recommends that both evaluations be done at the same time. If it's believed the student may be eligible for gifted education. And then ideally, if the child was found to be eligible for gifted education, the gifted teacher would join the IEP team and the gifted education supports and services would that be included into the IEP instead of having that separate GIEP. And that just final note, I'm saying it again, parent participation for multilingual families. We really want those qualified interpreters at meetings, proficient in both languages. It's so helpful if they can understand some special education terminology. We want to make sure they remain in their roles during the meetings. They are interpreters. They are not explaining things to the parent. They are not, there are obviously going to be instances when we've had interpreters who've had to ask the parent, can you say that again? Or can you really re-explain what you're saying? I'm not able to translate it. But we want them to remain in their roles in the meetings. Sometimes we have community members come in and say, I'll interpret for the family. We want to make sure if that's the case, that they really stay as the interpreter. Don't want a situation where they're saying, oh, don't ask that question, family. Like, you don't need to ask that question, because then they're there more as sort of like a friend and advisor to the family. And that's a different role. They're welcome, the family can certainly bring them in that role, but we want to make sure that we have someone who is translating and interpreting I don't want to say word for word. I know that's not possible for every language, but to the best ability we can, exactly what the parent's saying without flavor or color or commentary. I know that some schools will pull siblings from classrooms to do the interpretation. That's really not appropriate because the children need to stay in school and the school needs to use outside interpreters to do that. I have worked with families where they want an older child who does speak both languages to just be there with them. That, is the family's option. But I just want to make sure we're not pulling a sibling from math class in order to interpret for the family when there are other options there. And again, we want to make sure that those documents are fully translated as well, recognizing that it does take some time, for example, to translate a very long IEP. Um, there may be some instances when FAPE cannot be delivered to the family. And in those situations, I'm sorry, not to the family, to the student. And in those situations, the student may be owed compensatory education services to make up for any services that were missed. Some ways that might be because the IEP was old or inappropriate. So maybe there's no current IEP or the IEP doesn't meet the student's needs. Maybe goals were missing or stayed the same for several years. I mean, it's a big flag. If the goals are staying the same from year to year, then either the goal is not appropriate, maybe not achievable, or needs to be, or isn't measurable in a way that makes sense, or we don't have the appropriate supports and services in place in order for the child to make progress towards achieving that goal. Sometimes we have present level data that's very old, very wrong. So we want to make sure that that information is up to date also. Because if we don't have, of course, appropriate present levels, there's no way we can create meaningful, specially designed instruction for that child. Sometimes just supports and services weren't able to be provided. The speech teacher went out on a medical emergency and we weren't able to get a substitute in for 3 months despite advertising for the job. Like, it happens. We wish it didn't, but of course life happens. And so, that child would be owed for whatever minutes they missed for those 3 minutes. I'm sorry, for those 3 months that they didn't have a speech instructor. Maybe there were delays or disruptions in service. Maybe a child wasn't able to attend school due to transportation barriers or lack of staffing. So the student required a PCA for toileting needs and other needs. And unfortunately, the PCA quit and we didn't have one for several months and it wasn't safe for the child to attend school, right? That's one example. Or the child requires specialized transportation. I had a child who required a very, very specific harness and he wore through that harness every couple of months. And then it would take them a while to get this very specific harness that the child required. And so for those 2 to 3 weeks, the child was at home because they couldn't figure out a safe way to get them to school. And of course, It may not surprise you to know we said maybe you should have one as a backup instead of waiting until it fails to then go out and find one. And then there are certain situations where if substantive changes were made, for example, there were really material and substantive impacts to FAPE, and the parents were deprived of their right to participate in the meeting, that the child might be owed compensatory services as well. In terms of removing special education eligibility, IEPs and 504 plans do not expire. We hear this from parents sometimes. If you've ever seen the front page of an IEP, you'll see it's like the duration and it puts an end date on it. Which certainly doesn't mean that then, the child no longer gets FAPE or that the program goes away or anything like that. It's sort of unfortunately written on the front of I think, on the front of IEPs, but they certainly don't expire. An IEP follows the student to a new school. In order for a school to exit a student from special education, they need to complete a reevaluation. That may include a review of progress reports, grades, teacher surveys, etc. Getting good grades can't be the sole reason why a student is exited from special education. And keep in mind that parents do have the right to withdraw their consent at any time, their consent for special education services. Let's see, we've got about 6 minutes left, Megan. I was gonna scroll through discipline of students with disabilities, but let me know if it makes more sense to do questions instead, and I can skip to resources. What do you think?
Yeah, I think whatever I think if you want to move through these slides in the time allotted, there are a few questions, but just mostly similar to what I had lifted up earlier, and maybe
Okay,
one new
so we
one.
can follow
So
up on those
we
separately.
can follow up. Yeah, and there's just one about the 504 plan. Does it follow the student to college? Is the only 504 question we have.
A higher ed question. You've got me stumped. I'm not sure. I'm not sure, but I can find out.
I'll
Yeah,
add that to the list to follow up.
thank you.
Thank
Thank you. All right, so discipline of students with disabilities. Students with disabilities have all the due process rights and protections as their non-disabled peers, with the big caveat that students with disabilities should not be disciplined for behaviors linked to their disability. When I say students with disabilities have these extra protections, I am also referring to students who maybe have not yet qualified for special education, but the parent has requested a special ed evaluation, or if the parent has notified the school in writing that the student needs special education, or if the school staff express concern over a student's behavior to special education officials. So I will scroll through to the slide on sort of those additional protections in a moment, but a student with an intellectual disability cannot be suspended for any amount of time without the agreement, the express agreement of the parent, the Department of Education, or an order from a hearing officer or judge. If for some reason a student with disabilities is ultimately expelled from a school, the school must arrange for FAPE for the time the student is excluded from school. So that FAPE requirement never goes away. I am going to pop over to, and again, you'll get the whole slideshow. So if you want to peruse them, feel free. I move forward here to manifestation determination reviews. If a school wants to suspend a student with an IEP or a 504 plan for more than 10 days in a row, 15 days total in a school year or 10 days total for a pattern of behavior, that is considered a change in placement. And a manifestation determination review is required. What is a manifestation determination review? It is a team of knowledgeable people, a team of people who are knowledgeable about the student, including the parent, and they will get together and decide whether the conduct that this child engaged in was a manifestation of their disability or if it was due to the school not implementing the IEP. And if that is the case, then there cannot be an expulsion. And then the IEP team must conduct a functional behavioral assessment or revise the positive behavior support plan. Parents have the right to request special education hearing to challenge that determination. One example of not implementing the IEP might be student is required that if they tell the teacher, I need to go to the quiet space, I am feeling overwhelmed, they are always permitted to go to that quiet space. There was a substitute teacher that day who wasn't fully versed on that. The child is saying, I have to get out of here. I really have to get out of here. And the substitute teacher says, you are not allowed to leave. And then there's an incident where the child lashes out. In that situation, we would look at, I mean, the IEP says the child is allowed to go to the quiet room. They were not permitted to go to the quiet room. And this situation escalated. We really don't think that this child should be disciplined for their behavior when they did what they're supposed to do via the IEP. One exception to that is if the infraction that the child supposedly did involves possession of a weapon, possession of drugs, or the infliction of serious bodily injury. In those situations, then a child can be immediately transferred to another program for 45 days or temporarily without the manifestation determination hearing. Of course, that's a matter of safety. So I'm just going to quickly note here that I do have these additional resources where I've hyperlinked to what we already have on our website on special education resources, 504 plan resources, whole lot on multilingual learner resources. And we try to post our videos on here as well. School discipline resources, each of those also touch upon sort of specific discipline issues for students with disabilities. And that hits our noon mark, Megan, so I can end there.
Mm, perfect timing. Thank you. Do you have like a minute or two to stay if someone wants to unmute and ask their question? Maybe we'll give like 2, 3 minutes if anybody wants to unmute and share their question that they might have asked in the chat or one that popped up, and then we'll end. Go ahead, Megan.
Yeah, I put it in the chat. I just had a quick question about the minimum number of hours that students would receive direct instruction in English for multilingual learners. I didn't know if there was a minimum requirement or not.
I don't think that there is a minute requirement. But we may, and I can send information on this on breakdowns of sort of depending on the level of language acquisition, in terms of like days and how often it needs to be provided, specific ESL instruction. But I don't think I have.
Okay.
Thank you. I think we have time for one more question. Okay. Well, thank you all so much for being here. Hito, thank you so much for being here and sharing your expertise with us and sharing your slides and your resources. I put the session evaluation in the chat. We truly value your feedback about learning series sessions, so please take the time to do that. If you need to apply for Act 48, there's an Act 48 application that follows the evaluation. Big thank you again to Hito and to all of you for being here. Have a great rest of your Thursday, and I will follow up with all of the resources from today's session. Thanks.
Thank you.
Thank you, everyone. Have a great day.
Thank you. Thanks for being here, Joe.
Yep.
Bye, everyone.